All right, we've turned on our live feed, preparing for our landlord tenant docket this afternoon. We have about 10 of those and a couple of civil matters. No small claims today, so we should be able to conclude by 2:45 or so, perhaps. We're a little early, but people often log in early too. Well, about 5 minutes till go time.
Hello, Judge.
Good afternoon, John. Have yet to see Bettina. I'm hoping that the Rhodes case, the checks cleared and that case got resolved.
As of Friday, it hadn't. I don't know if anything's happened since Friday.
Yeah, that was June 14th when we were here last, 2 weeks ago.
Maybe we'll have good news.
Good afternoon.
Good afternoon.
I almost said good morning.
Somebody called me about 11:30 and said good afternoon, so we're all disoriented. I do that a lot.
Mhm.
We are on the live feed and I've got the recording on. And we were discussing the Rhodes Roy case way back June 7th, $7,500 was approved. So we adjourned it a week to June 14th. We adjourned it 2 more weeks until today. Has that check been cleared?
Yes, I was told that it was mailed on June 23rd.
Well, if Chris Corpening logs in, maybe she can enlighten us.
There's a good chance it could have been delivered Saturday or Monday in the mail, so we hopefully we'll be okay.
Good afternoon, Miss Lafleur. You're here at the right time at this point, so you're in the right spot. We'll get to you here in just a moment.
Okay, thank you.
Put you in the waiting room while we wait. At this point, I guess you all know the CDC moratorium was extended 1 more month to July 31st. And they say that's the last time they're going to do it. We'll see.
Yes, indeed.
John, we're just waiting for the clock to tick to 1:15.
Is Chris hooked up?
Chris not here yet. I have a case with Richard Walker and Marilyn Lafleur also set at 1:15 because I was assuming the check would be processed and this case would take not much time, but maybe it still won't.
I've got the 125 and the 135 if you want to put me in the waiting room or whatever you're on.
No, you're fine. You can assist. Yeah, we got Smith and Clark. We set these on 10-minute intervals. Then I've got a couple of civil matters and we pick up again at 2. And a number of those have got funding in the works. So I'm hoping Bettina gives me a bunch of good news today.
You got it.
Yeah, you're stuck here anyway for a bit, John, but I don't have Mr. Walker here yet on Marilyn Lafleur. Here's Chris. Marilyn, I can hear your wind chimes. I'll put you back in the waiting room for a moment.
I'm sorry.
That's all right. All right, Chris Corpening has joined us. We can get her to unmute her microphone. We'll call this case. This is file 21429 LT. It's entitled Memory Lane Mobile Home Park versus Donald Rhodes and Nicole Roy. First hearing was way back in April 30th. It was continued to June 7th. And at that time, Bettina Emery advised us they had approved $7,500 worth of funding. As of June 14th, the check still hadn't been received. And as of today, Bettina said the check was mailed June 23rd. Has the park received that payment?
Yes, Your Honor, I received it this morning.
All right.
Yeah.
And that would pay the rent through when?
That pays it through his, I haven't done the math yet, but they did forward 2 months forward.
All right. So John, at this point, do you wish to dismiss this or?
Yes, I would have no objection with that.
All right. Defendants has a right to retain possession. Payment has been made in full. Okay, while we're waiting for Mr. Walker, we had Austin Smith and Josephine Koontz. Has anything been paid on that one?
No, Your Honor, nothing's been paid.
Oh, this is the first hearing. These are both first hearings.
Yes.
That's
So,
correct.
yeah, no, paid, and we got to get them in here and advise them of their rights. Have those people contacted Keystone? Austin Smith, Josephine Koontz, or Abram Clark?
Austin Smith and Josephine Koontz, we are currently working with. Mr. Clark, we have not heard from.
This is file 21745 LT. It's entitled Richard Walker versus Marilyn Lafleur. We were here on May 28th. We adjourned the matter for the required 30 days. Marilyn Lafleur is present. The plaintiff is not. This was a property at Cottage Street in Sturgis. It was filed as a demand for non-payment of rent. Mr. Walker represented that he was really more interested in getting the property back as he was trying to put the property up for sale and listed it with a real estate agent. Ms. Lafleur indicated that she was trying to move. Ms. Lafleur, Mr. Walker isn't here, but what's the status of this?
Okay, I found a place to move, but I was in the hospital for 8 days. I got out on the 21st, and I can't do anything for 2 weeks. So I need a little more time. I can get back up to get my stuff out of the house.
All right. I don't know where he is.
I haven't heard from him. I have my new address, but I don't want to give her a phone because I don't want Ronnie to know where I am.
All right. So you're prepared to move, you just haven't got your things out.
Right.
All right, if we don't do anything, you would get 10 days from today to move. This is filed as a demand for non-payment of rent. The Centers for Disease Control have extended the eviction moratorium until July 31st. If you file a CDC, or request for stay of eviction, can't do anything until July 31st. If you choose not to do that, you would have 10 days from today to get your stuff out. What would you prefer?
How do I file that thing you're talking about?
All right, you can just look it up on the internet, CDC stay of eviction, and print one out. I thought we'd sent you that information, but I may be mistaken. I'm going to ask you to hang around for a little bit because Mr. Walker is supposed to be here on another case, but that's not till 2:15. I'm not going to make you wait 45 minutes, but I will leave you here for just a bit.
Okay.
What I think I will do if he doesn't appear is I'll give you 10 days to move. And if you file for the CDC stay of eviction, it would not enter until after July 31st.
Okay.
But you just stay here for a few minutes. He's the kind of person that might show up late or been confused or something. But he does have another case, but I'm not going to make you wait for 45 minutes. But I will have you wait a few, so let me put you in the waiting room.
Okay, thank you.
Now we've got to wait till 1:25, and that time is coming up on us. I was hopeful both defendants would long it at the same time so I can advise them of their rights simultaneously.
We have service by attachment on both those matters, Your Honor.
Well, Smith and Koontz, it says P and S. Let's take a look. Personal service on Dustin Smith and Josephine Koontz, meeting place only. So it looks like Smith and Koontz, Sergeant Morse found them.
I guess I wasn't sure how to understand that.
I'm having trouble reading this. Yeah, he describes them, both of them. He served them personally. Clark, I did have attachment service. Between Sergeant Morse and Dick Meddy, generally they find who they're looking for. We've got some good process servers, and we have a lot of out-of-county people I don't know as well, but those two do the bulk of our service. Well, according to Bettina, they're working with Smith and Koontz. So that is something, but I'm hopeful they log in here. Now that we have people coming in and out of the courthouse, it's noisy out there in the hall once again. It had not been for a long time. All right, it is 1:25. We'll call our first case. Michiana, Memory Lanes Mobile Home Park versus Austin Smith and Josephine Koontz. This is filed as a demand for non-payment of rent through June. Rent is $3,920 in arrears, according to Mr. Bush's breakdown. We've got late fees and pet fees for an additional $450, plus costs $207.20, for a total of $4,577.20 to retain possession. We're looking at the documents, and then we do have personal service. Defendants are subject to default since they are personally served. Our housing advocate, Bettina Emery, is here from Keystone. She indicated before we started this record that the defendants have been in contact with Keystone for emergency housing assistance. Mr. Bush, what's your preference here?
Can I just have a moment to talk to Chris, please?
Yeah, sure. I'll put you in the breakout room. In the meantime, maybe they'll show up. Bettina, when did they contact you guys?
Your Honor, I don't have their file in front of me. Their file has been sent up for review. Offhand, I want to say maybe the beginning of June.
All right. Tina's checking on when they made contact, but she believes it was early June. What's your preference, Mr. Bush?
Since they've contacted Keystone, we're willing to roll for another period to see what happens on this.
Then we'll reset for 28 days, which would be my first day back from vacation. I believe it's 27 days, but we're going to go with the 26th. At 2:15.
For purposes of managing my schedule, are these going to be face-to-face, or are we still contemplating remote at this point?
I'm contemplating doing Zoom for our landlord tenant matters, continuing. Part of the problem is Judge Stutzman was in the middle of a murder trial, and then he was at a judge conference, and Judge Tomlinson was gone and is gone this week. We haven't had a chance to sit down and talk among the four of us. Rob and I have talked, but my intention is to continue to do most civil functions by Zoom.
Well, that's fine.
So assume it'll be Zoom, June 26th at 2:15.
You said June, I think you meant July 26th.
I did, I meant July 7/26.
And obviously, if they don't follow up, this would be the second hearing for them, so we
Yes,
could move forward then.
they'd be subject to default. Now, our next matter is Memory Lanes and Clark, and that is not set until 1:35, so we gotta let 5 minutes tick. In the meantime, I'm gonna bring Miss Lafleur back in. Miss Lafleur, your landlord has not appeared. So it's somewhat difficult to proceed. We're here, rent was $750 per month, 2250 plus 750. I'm gonna say that rent is through June is $3,000.
But I only owed him from April,
April,
May,
June.
May and
Oh.
June.
All right, let me look at the date of that other hearing.
That was May 28th.
Maybe I'd already calculated it through June. 2250.
Yeah, he had it add up wrong.
Well, he's not gonna, he just wants you to move. Court
I know.
costs. $55 and $51.20, filing and service fee $106.20. 2003 56.20. Due within 10 days, which would be July 7th. Unless if the defendant files a CDC stay no action until July 31.
Okay, and if I moved out before July 31, then I don't owe anything but court costs?
Well, you don't owe anything at this point unless you
Okay.
wish to stay there.
No,
If you
no.
wish to stay there, you pay the money. If you don't wish to stay there and you move, you need to turn in your keys and give your forwarding address within 4 days of your moving. Then if he wants to sue you for money damages, we can have a further hearing.
Okay. Then I can just
He's
call
gonna-
can I just
I'm
call
sorry.
your office saying, give them my new address?
Well, you have to give it to him. You can call my
Okay.
office and give it, but you have to give it to him in writing and
Got
turn in the keys. I'll
Okay,
do a temporary order with CDCC. If he shows up for his next hearing, I'll tell him what we did, but I'm not gonna make you wait all that time. All right,
Okay.
thank you. We'll send you a
thank you so
copy.
much.
All right,
Okay.
thank
Bye.
All right, Mr. Walker could use you as counsel, John.
I've known Richard since I was about 3 years old.
Yeah, I know you knew his parents also. Okay, we'll wait one more minute. This is Memory Lane's Mobile Home Park versus Abram Clark and any others. It is a non-payment of rent case. The arrearage is alleged to be $2,240. Filing fee is $176. Some late fees $120 for a total of $2,536.16. The defendants were served by attachment, and they're not here. Ms. Corpening, is the defendant still there?
Yes, Your Honor, he is.
Well, the law requires I do at least 7 days notice when we have proof of service. They're not eligible for a default. So let's take a look and see if you're here next Monday.
Next Monday is 4th of July.
Oh, so that would take us to the 5th, or the 2nd, which is just jam-packed, but we'll stick it in there because then are you here on Friday, John?
This Friday?
Yeah,
No, I'm going to be here in the morning, then I'm going to be in Cincinnati. Leaving.
that's right.
Actually, I'm going to be in Cincinnati and doing it remotely in the morning. Hopefully, I'm going to be at Great American Ballpark parking lot by mid-afternoon.
Good for you. Problem is, then I'm on vacation, and I don't really want to extend this all the way to July 26th. Yeah, I don't want to have you log in the middle of your vacation.
Well, it's a short vacation. I'm just going to be off Friday, and obviously Monday we're closed for the 4th of July holiday.
Well, you deserve it. I don't want to make you come in for this in the middle of a ball game. Well, I apologize. I'm going to set it at the same time. Perhaps they'll contact Bettina in the meantime. July 20th. Well, no, I'm here the 9th. Are you available on the 9th?
Let me check.
That would be in the morning.
On the 9th, I have a hearing in the morning, but I'm free all afternoon.
Well, we got landlord tenant in the morning. I could do it, say 10:45. Where's your hearing on Friday morning?
It's an adjudication case and abuse and neglect plan. So it'd be in front of-
That's gonna take all day, isn't it? What time does it start?
Time is adjudication. Yeah. It's set for 9. If you can do it earlier, I'm in the office well after 7 every morning.
All right, how about if we set this for 8:30?
Thank you, Judge. I appreciate that flexibility.
8:30 on July 9. Just start things up early. It's not a terribly busy morning, but it probably could be because I've got some vacation time after that. All right, so they failed to appear. We have to adjourn at least 7 days. That will be 10 days to July 9th, but it's better than going all the way to the 26th. And it doesn't interfere with your vacation.
See, I'm doing a few things remotely from Cincinnati that morning, but I want to keep it to a minimum.
Yeah, I remember you got last pre-trials. In the meantime, if they do get a hold of Ms. Clark, they could well be eligible for some emergency assistance. So, Ms. Corpening, if you do have any contact with them, point them at Keystone and see if they can get some emergency help.
Okay, yep.
All right, John, I think that takes care of you.
Thank you, Chris.
I've got some other things at 2. All right, thank you. Now, I have, Bettina, a couple of civil matters at 1:45, so you can just either click your camera off and just wait, but then we've got Nichols and Bluestream and a couple others, so theoretically, I have a couple of civil matters here at 1:45.
Cool.
All right, thanks.
You're very welcome.
Good afternoon. Who am I speaking with?
Lynn Friend.
All right, let me give you a name here. LYNN. We'll let the clock tick here for just a couple of moments, and that's set for
Okay.
1:45. I'm not sure the plaintiff is going to show up. They emailed this morning. We'll make a record here in just a minute.
Okay.
Oh, here he is now. Good afternoon. This is Judge Middleton here at the court in Centerville, and I have Attorney Neil Jensen in here on behalf of a plaintiff, TD Bank USA, and the defendant Lynn Friend is here by telephone only.
Your
This
Honor,
is a claim,
Your Honor.
yes?
I'm sorry, this is Neil Jansen. Your Honor, I'm sorry, I'm here for the Bluestream capital matter versus
Oh,
Volkert, which is.
I'm sorry.
Your Honor.
We'll get to that in a bit.
Certainly.
That's set for 2, so you're a little early.
Yep, I dialed
all right.
a little early.
Okay. Well, then, I won't drag you into this unless you'd like to
Thank you.
be in here. Ms. Friend, I received
Yes.
an email from the plaintiff in this case earlier this afternoon asking to adjourn the matter. They sent you an order for dismissal and they're waiting for that to be returned.
I faxed that back to him on the 20th of May.
Wow. 20th of May or 20th of June?
The 20th of May.
Yeah, we were here. On June 7th. It'd be helpful if they were here.
Yes, sir. I can fax that again to him tomorrow, but I
Yes.
faxed it on.
All right. Well, you didn't mention that at our hearing on June 7th.
I didn't know what I was doing.
All right. Continue to at the request of both parties to allow receipt of dismissal. So, yeah, you need to fax that back to them again tomorrow.
Okay. They have been paid. They
Yes.
settled on $970.
All right, I'm going to continue this
Okay.
to Friday, July 9th at 10:45. Hopefully it'll be dismissed.
Okay.
Last
At what time again, sir?
Friday, July 9th at 10:45.
Okay.
We'll send you a new notice.
Okay.
All right, I can't tell what happened, but they said it was a debt consolidation company beyond finance, and there had been a satisfaction. And I don't know where that dismissal is, but you need to get it to them so they can get it to me, and then we can just dismiss the case. Okay?
Okay. Yes, sir.
All right, thank you. You're good to go.
All right. Thank you, sir. Bye-bye.
All right, bye-bye. All right. Now we have a 12-minute time gap where we sit here and count how many angels can fit on the head of a pin. But we had some problems with that land contract last time. Let's see if we can get that straightened out here today when they show up. I have another matter set exactly at 2, and yours is set at 2. The other may be contentious.
I did file a corrected,
Yes, I have it.
and that would have the correct land contract is attached.
All right, I will operate with that one.
Thank you, Aaron.
Kind of going in fits and starts here this afternoon.
Usually people are delayed instead of being early.
Well, we're discussing whether and to what extent to go live again. I shut the record off, but we are still on the live feed about what to do by Zoom, what to do live. For civil practitioners like you, Zoom has been a huge boon. Otherwise, you'd had to drive to Centerville, and you don't even know where Centerville is, and we're able to do it efficiently like this. My intention is to continue to do these sorts of hearings by Zoom. And I asked another lawyer this morning who practices in Grand Rapids area what she was witnessing. And people are kind of all over the map. What are you seeing? Are other courts starting to open things up for civil cases, or are they doing it continuing by Zoom?
I agree. Things are all over the map. I've got hearings in northern Michigan that are live. And then I've got hearings in the Grand Rapids area, which are by Zoom. I had a trial that was scheduled, a trial for Zoom that's been now reset for live trial with a date uncertain yet. But so
What kind of trial is it?
it's a district court trial, just a contract, land contract dispute, actually.
Okay.
So they're kind of all over the map. I do agree that these are certainly much more economical for the client. Like you said, instead of charging the client to drive back and forth.
Well, I talked to an old classmate who practices in Grand Rapids and how it had changed the economics of his practice. You're not billing clients for drive time or overnight time, but you are certainly more efficient with your own time. So I'm here anyway, although it's caused problems for us in that I have to be glued here to the bench to proctor the hearings before I would wait in my office until people accumulated in the courtroom, then I would come in.
Right.
But if we schedule a hearing for 9 o'clock, I'm here at 9 o'clock to begin, whether the parties are or not. And so we'll see. But now, change is hard. We've changed one way, and now we'll determine whether we're going to change back. Mr. Nichols, you're here in a timely manner. We're waiting for 2 o'clock to call the case, so it'll be a couple of minutes. So I'll
That's
just
fine.
put you in the waiting room.
Thank you.
I wonder how that
yeah.
was working for your schedule and other judges' schedule, whether they found it, you're able to manage it more easily manage it, or it was more of an imposition.
Well, many judges, in fact, most judges have someone that manages the Zoom and the related recording in YouTube. I don't have anyone in here but me. There's no clerk, there's no assistant. I'm running the Zoom feed, the YouTube feed, and the recorder, which probably isn't the ideal way to do it, but that's how it's done here. At least it's morphed into that. And so I guess we'll see how it all comes together. But my intention is to, in fact, the Supreme Court encourages us to do as many things remotely as we can. And so
Well, I think it certainly makes sense for things like scheduling conferences and things of that
Oh, it
nature.
certainly does. When you've got counsel on each side, having them drive all the way down here to do that. But even these things, the defendants are becoming more accustomed to doing things by Zoom. And some people do struggle every day, but others, they become used to it and they're more adept at it. So we'll see. The world changes as we stay in the same place.
The trial that I had here, the district court trial, we were unable to go forward because the other side's party had a poor connection. She couldn't connect very well. Sometimes she had no audio, other times she had really poor audio. And her attorney also had poor connectivity. So it was we spent about an hour trying to wrestle with that. And then the judge finally said, let's just schedule this for a live trial.
Those kind of things are what turned my hair gray. It's frustrating trying to do it. We do have a room here at the courthouse where people could come and actually be here with a good connection. So we try to adapt, but it is very frustrating to try to do a trial with a poor signal. To do anything, a plea or,
Right.
But certainly not a trial. All right, here's a telephone number. Let's see who this is. We actually have 3 things all set at 2 o'clock, which is not ideal. We'll see who this is. Good afternoon. Who am I speaking with?
This is Christine Volkert.
All right. Let me give you a name. All right, let me turn the record back on. We are ready to begin in your case. This is file 21771SP. It's entitled Bluestream Capital LLC versus Christine Volkert.
You can get a check every month.
Mr. Walker, I'm going to put you in the waiting room while you're struggling there.
But
we were here a couple weeks ago. Let me get the date correct. We were here on June 14th. Mr. Neil Jansen is here for the plaintiff. This is a land contract forfeiture action. And I went through the rights that you have as a land contract defendant in court. The problem is the pleadings they had filed didn't have accurate information on it. They now have filed an amended complaint dated June 15th that sets forth the current arrearage. The original selling price was $34,900. Presently, the arrearage is $1,875. Do you agree with that or disagree with that, Ms. Volkert?
I agree with it.
What's your intention?
Well, I actually just moved back into the house. I'm trying to get help with it. I left the co-defendant, I guess you would call him, and he stopped paying the payments. When I found out, I moved back in. I'm trying to get caught up. I don't know what else I can do. I've spoken to several help agencies, which sent me to Keystone Place. And they said I had to do court first and then call them and let them know what the outcome was. And that because of COVID and everything, that they have extra funds to help.
Well, we certainly do have, we do have emergency housing funds. I do not know to what extent they're available for land contract. Bettina, could you join us?
Yes, Your Honor. We're not able to help with land contracts.
That's what I thought. Do you have other programs to help?
There may be another program, but I am unaware of that at this moment.
Okay.
Well, the figures are in agreement. I've gone through your rights. You have, you're going to have 90 days. Less than 50% of the contract price has been paid.
Right.
I don't have an order here. I don't think I have the. So you get 90 days to bring the contract current.
Okay.
I think I have. Here's the plaintiff of Blue Street Capital. So the current arrearage, the parties agree, is that through June is 1,875?
That's correct, Your Honor. 5 months, February through June.
$1,875. And she's going to have 90 days to redeem that, which from the 28th of June takes us to the 27th of July, the 26th of August, and the 26th of September. So the due date is 9/26.
Okay.
Mr. Jansen, who would you like to be the point of contact? You or the client.
For payments, Your Honor,
Yes.
she can make direct payment to the client, Bluestream Capital. Is that correct, Mike?
Yes.
Thank you.
Okay.
You also do have 10 days to appeal this, but you seem to be in agreement with the figures. So
Right.
I don't have an order here. Would you submit one? And,
I will submit an order. I thought I had, Your Honor, but I will submit one.
well, I looked to see if I had one from before and I couldn't find it. But,
I'll send that down today.
okay, let me make sure I don't have one there in the back.
I have a question. So
Yes.
if I cannot get the full amount paid by September 26th, is that the date that I have to be out of the house?
Yes, you'd be subject to eviction on or after that date,
Okay.
as opposed to traditional rental when you have 10 days. And any stay, CDC stay, will expire July 31st. All right, 26th of September. We will forward a copy of that to you at this address, 240 South Washington Street.
Okay.
I'll fill those dates in on Your Honor and then send you one.
All right, thank you. All right, any questions, Ms. Volkert?
I don't believe so.
All right, thank you.
Thank you.
All right. Mr. Francis, release him. I'll wait the order. All right, let's bring in everybody else we've got here waiting. We had several things all set for 2 o'clock.
So you
I've got a phone numbers here.
We can find you a doctor that says that you're.
Richard, you're in court now. I brought you into the feed, so would you take your hat off and stop your other conversation? I've got a telephone number here. Who am I speaking with?
Richard.
No, Richard, I got you. I've got a
Longacre.
All right,
I
let
just
me
lost your phone.
all right. All right, then I've got another phone number.
I do like this court better than the old court.
Good afternoon. Who am I speaking with by telephone?
This is Pantoya.
Oh, he's just talking to other people right now.
All right. Richard, I'll put you in the waiting room. All right, Miss Pantoya, let me. YYYMMDD. All right, everything happened all at once here. Then I've got Kevin Kelly. We have a civil matter. We had 3 things all set at 2 o'clock. We're gonna take care of Bluestream. That one was just done. It's a land contract forfeiture. We have HZ CNAC Inc. versus Ashley Longacre on a continued motion to set aside a default. Mr. Tyrone Fleeman is here on behalf of the plaintiff, and Ashley Longacre is present. We had a hearing some months ago, and the defendant failed to appear, and a default judgment entered against the defendant. She then wrote a letter to the court essentially asking to set the default aside, saying I'm sorry, I missed the date, and then alleging defects in the car. We made a somewhat lengthy record on June 14th. Mr. Fleeman indicated these properties were sold as is with no warranty. He objected to the setting aside of the default because defendant filed more than 21 days after the default entered. She pled no good cause for missing the hearing and stated no meritorious defense. We did agree to continue the matter for 2 weeks at that time. Mr. Fleeman, what's your position here today?
Good afternoon, Your Honor. Tyrone Fleeman on behalf of the plaintiff, and I have submitted to the court a couple of exhibits to go with this. From our last hearing until now, I was able to pull some documentation from the client, CNAC, and exhibit number 1 shows the service contract that Ms. Longacre did have on the property, but I submit it mostly because it shows the vehicle mileage at time of delivery, 89,516 miles. Now, mind you, this is on an 07 Ford Explorer, and that was sold in 2016. The exhibit number 2 is referred to as a bad debt recovery worksheet, and I submit that for line number 12, which specifically says vehicle repossession mileage of 121,560 miles. The third exhibit that I submitted is a list of all of the vehicle service reports. I'll come back to number 3 in just a minute. The interesting thing to observe from numbers 1 and 2 is that over the course of almost precisely 2 years, from November 25, 2016, until November 19, 2018, the defendants, I think this was mostly Joe that was driving the vehicle, but I'm not positive, logged 32,044 miles, which averages out to 16,000 miles per year. So the idea that you can buy, that Ms. Longacre could purchase a car, you know, with that many miles on it in a used status and of that age, and still and got 16,000 miles a year, kind of belays the idea that somehow there was a mechanical difficulty with the vehicle, and that's why she turned it back in. What further puts down that argument is that when you look at exhibit number 3, and I'm sorry, it's a bit difficult to read because it prints off landscaped like that, you can see that the very first time the vehicle was ever brought in for an oil change was after 19,502 miles from the time it was purchased. The technician even says the oil was very bad, brought in a sample, a piece of paper, and it was quite dark. And then you'll also, if you take the time to crunch on through the rest of these service reports, you'll see that there was a time when there was a leaking hose, it was leaking some transmission fluid, and there was a coolant, not from a hose, but from a housing or a thermostat coupling, I think it was. And those were both fixed under the service program. She or Mr. Wilson paid a $25 deductible, but those repairs were covered. Now, what I didn't submit to the court, because it's really difficult to read and wouldn't make a whole lot of sense, is the customer service notes from CNAC as between them and Mr. Wilson and or Miss Longacre. And the long and short of that is that it looks like until about November of 2018, Miss Longacre wasn't really involved with the vehicle. It sounds like more it was Mr. Wilson that was involved with it. But at November the 10th, she called in and said she didn't want anything, because she didn't want anything to do with Mr. Wilson. And that's when she told them to come pick up the car, and they said, give us the address. And so she gave them the address. That was on November 16, 2018. And she sent the address to CNAC, and they went and picked up the vehicle. So it appears that this was a situation where she just didn't want that vehicle anymore, because it was really more Mr. Wilson's vehicle than it was hers, but I don't want to put words in her mouth. Long and short of it, I don't think there's a valid meritorious defense to this claim.
All right. They supplemented the record with that additional information. Ms. Longacre, anything else you wish to say?
No, I mean, just a bad mistake, I guess, you know.
All right. The motion to set aside the default is denied.
Do you need an order to that effect, or do you have an order?
No, I would request one. I don't have one. The default as to Joe Wilson stands.
Correct.
But as to Ashley Longacre, the request to set aside the default was filed more than 21 days after the default entered. There's no meritorious defense, and there was
I do
no
have one
good reason
question.
for missing the hearing. Yes?
Am I reliable for the full amount?
Well, you're liable jointly and severally. Whatever they can collect from Joe Wilson is less than they'll collect from you. But if he moves to Australia or goes to Mars or something and you're the only one available, then they can collect it all from you. But theoretically, you're jointly, meaning half and half. But you could be completely liable if he does not pay.
Okay.
All right, he's going to submit an order.
I'll submit that under the 7-day rule, Your Honor, and I'll just say that for the reasons set forth on the record, the motion to set aside is denied.
All right, thank you.
Thank you, Your Honor.
Any other questions, Ms. Longacre?
Yeah, what is the total amount that I'm looking at?
Let me flip back to the original judgment. A lot. Judge Pattison actually signed this when I was in Florida. $12,729.85, and it is accumulating interest. So it's going to continue to grow.
Okay, thank you, Your Honor. I will submit that order.
All right, thank you. All right, Ms. Longacre, you're good to go.
Thank you. Bye.
All right, all right, Mr. Freeman did that. All right, we've got a number of other matters set here. Let's bring everybody in. We were cruising along in pretty good shape, and then everything happened all at once. We've got Nichols and Pantoya, Walker and Massaro, Barnett and Mock, DeGrow and Lozier. And Luke, I can't remember which one of those are you here on?
Nichols Pantoya.
All right, we're going to start with that one because that is the actual 2 o'clock case. Ms. Pantoya, can you hear me?
Yes, sir.
This is a landlord tenant case. The file is 21653LT. It is filed as a demand for non-payment of rent. We made a finding when we were here on April 14th that the arrearage was $47.42, pretty substantial. And then we were here on June 14th, and Keystone had been involved in the process. Bettina Emery is here with us. They were waiting for the check. Bettina, has Keystone been able to provide assistance in this case?
We have. We had to finalize some documents, and right now she's pending final approval.
For how much?
That, Your Honor, I do not have at this time.
Luke, what's your preference here?
Well, as far as I had known, this was up to last week that, we were awaiting the finalization. I'm pleased to hear that Ms. Pantoya had followed through with her part. It is a substantial amount. I hope it's approved for the full fullest amount possible. At this point, we are looking for that. If there's assistance, then we wouldn't be moving forward, but I don't know what our options are here. I know we've.
Well, I had a couple of these with John this morning. As you can imagine, Keystone's been overwhelmed by applications. They do have sufficient funding to help the people. And it sounds like they were approved. What I would like to do is continue this to next Friday to see if Keystone can process the check by then. We keep kicking the can down the road, but Mr. Nichols gets his rent paid, which is important, and the defendant gets to stay there. Do you have any objection to that, Mr. Nichols, if we go till July 9th?
No, sir, I don't.
All right, I'm going to continue this. Luke, are you available the morning of July 9th? John's got a big landlord tenant hearing that morning.
The morning.
Excuse me, abuse neglect hearing.
Yeah, I have the same thing.
Could we do it before at 8:45?
Yeah, that'll work.
All right, I set John at 8:30. Let's set you for 8:40. And hopefully the check will be processed by then. If it is not processed by then, my inclination will be to go ahead and do the judgment with 10 days for payment, and then you can always use your discretion whether to execute it or not. All right, we'll continue that matter, Ms. Pantoya. You continue to cooperate with Keystone. Mr. Nichols, I will see you with your lawyer at 8:40 next Friday morning.
Thank you, sir.
Thank you, Your Honor.
All right, thank you.
Thank you. Bye.
All right. Goodbye, Ellen. All right, now we've got several other matters. See what was actually set next. Bluestream and Kelly is done. Walker and Massaro. Is Heather Massaro here? Is anyone here on behalf of Heather Massaro? Mr. Kelly, what case are you here on?
The one, I guess you already did, but I was here at 2, it must have been before 2, wasn't it?
What's that, sir?
The Bluestream Capital one. Didn't you already do that one?
Capital One.
No, the Bluestream, whatever.
Oh, Bluestream Capital? Yes, we did that. They're gonna submit an order. You need to take your hat off first. I didn't even realize you were here. I did it at 2 o'clock.
It was here at 2 o'clock. I must have been quick because I was here at 2 o'clock. I'm like,
Well, you probably weren't. I didn't realize you were here. You have 90 days to pay the arrearage or you're subject to being evicted. She was here and Miss Friend was here. She says you're no longer on the premises. Is that true?
no. I didn't know that. Nobody told me that.
It's true.
Ladies, I'm not sure what's going on. I have a terrible feed from the conference room. That's never happened before. Mr. Kelly, are you still there?
Yeah.
You have, where do we send notice for you?
I'm living at the house.
All right, Indian Prairie Road?
Huh?
On Indian Prairie Road?
No, 240 South Worcester Street, Koontz, Michigan.
All right. That's where we'll send the notice. You have 90 days to pay the arrearage or move, and we'll send you that notice at that address. I apologize for not bringing you in. I didn't realize you were here.
So they said I was not allowed back at my house?
She said she moved back in because you weren't there.
No, I've always been there. She moved out and she moved back in when I was there.
All right, well, either way, between the two of you, you gotta pay the land contract shortage.
Yeah, I know that.
All right, we'll send you a copy of that. You're good to go. Thank you. I'm not sure what's up with that. All right, Mr. Walker, we had a case with Marilyn Lafleur at 1:15 and you didn't show up. I wasn't going to make Marilyn Lafleur wait for several hours or 45 minutes for you to show up.
Your Honor, I talked to her and she lost her phone.
I'm sorry?
I talked to her this hour ago or so. She lost her phone a couple of days ago.
All right, well, I gave her until July 7th to pay $23.5620 unless she asked for a COVID stay. She indicated that she had found a place to move to, but she couldn't move her stuff. She'd been in the hospital. All right, well, let's call your other case, which is Richard Walker versus Heather Massaro.
Yes.
We were here on June 21st. There's no lease. Heather Massaro was here. You indicated you wanted to sell the house.
Yes.
And let's see who one of these people is. All right, we got Rick, who's on Old Town Road.
How's it going, Rich?
And that's Rick Loosier. Who's the telephone number am I speaking with?
I'm sorry.
Yes, who am I speaking with?
Heather Massaro.
All right, Miss Massaro, let me give you a name. We're waiting for you.
Okay.
This is file 21931 LT. It's entitled Richard Walker versus Heather Massaro.
Plug it in, Brooke.
Let me put this guy in the waiting room. This is a property on Maystead Road. There is no lease. Mr. Walker is asking to terminate the tenancy. We did set the matter for a hearing 7 days later. And he still wants you to move so he can sell the house. Ms. Massaro, what's your position?
Still working on moving out. Hopefully I can get everything out by tomorrow. It's the latest.
All right. Well, you get 10 days.
Okay.
I find that by hearing, plaintiff has a right to recover possession of the property on or after July 7th.
Okay.
No money judgment is entered here. If this is called a possession judgment, you also have until July 7th to appeal this. If you do move tomorrow or any day before then, it's your obligation to turn in your keys to Mr. Walker and giving him your forwarding address in writing. And Mr. Walker, are you getting out of the landlord-tenant business?
Yes, I'm done. I'm not cut out for that.
Well, Mr. Bush and I were here when we were waiting for you. I said you could have used John Bush as an attorney on these. I know you've known him for many years. But if you're going to get out of the landlord business and sell these houses, I guess then it won't be an issue. Ms. Massaro, you have 10 days to move or you're subject to being evicted. If you do move, you need to turn in your keys and give your forwarding address within 4 days of your moving. Okay?
Okay.
Do you have any questions?
No.
All right, you're free to go. Thank you. Mr. Walker, you're good to go.
Thank you, Your Honor. I really appreciate this.
All right.
Yeah, I'm
glad you're getting out of business. You got enough stress. All right, that leaves Barnett and Mock and DeGrow and Longacre. We have both parties on DeGrow and Longacre, so we're going to skip ahead to that one. Sandra DeGrow is here, and let me bring in Rick Longacre. Get him to take off his hat. Good afternoon, Mr. Longacre. This is Judge Middleton. Can you hear me?
I can, sir. Yes, sir.
All right, very good. We're here at a court proceeding. I'm going to ask you if you take your hat off. Thank you. You're in a car. Ms. DeGrow is here. This is a termination of tenancy case. We were here on June 21st. Both parties were here by telephone only at that time. The lease expired in May. Defendant is still there. Mr. DeGrow contended he never paid rent. His contention was he was doing some sort of repair. We had the hearing. The defendant showed up 15 minutes late. He says he's preparing to move but has no money. Because the defendant did show up, I had to continue the matter for 7 days. Ms. Longacre, Mr. Longacre, are you still there?
Yes, sir. I did, as you said, and started looking for other living quarters. And currently, there is one that's becoming available on the 15th. And I hopefully will be able to get things moved out immediately thereafter. But I was going to ask for, from the 15th, maybe 3 or 4 days.
All right, well, that's up to her. Right now, you get 10 days from today, which is the 7th of July. Mr. DeGrow, are you willing to wait till July 15th rather than go through the whole eviction process? I can't hear you. Just a minute. Mr. DeGrow, I can't hear you. You don't have your sound turned on. All right, now you need to unmute. Can you hear me now?
Yes, I can, sir.
All right, are you willing to extend it to July 15th?
I'd rather not. I've extended it from the time he moved in till now.
All right, well, it's up to you. The eviction is a big giant mess where the sheriff puts his stuff out on the street. Let me say this. This is our second hearing. The defendant was late for the first hearing, and we advised him, we set a second one. And I advised him of his rights. I'm going to tell you both something, and you need to listen. You have until July 7th to move, or you're subject to being evicted. Ms. DeGrow, you don't have to evict him on July 7th. You have 56 days from today to ask for the writ of eviction. So you have some discretion. By the letter of the law, if he has not moved, you can have the sheriff come put him out. It's a big mess. You have to come back to the court, pay $15 for writ of eviction. You can agree to simply let him move on his own if you wish. If you don't wish to, you can pursue the eviction. Mr. Longacre, my advice is to try to get out of there by the 7th. But I hear what you're saying. I hear it all the time. People would move if they had somewhere to move to. And it isn't easy to just snap your fingers and find another place to move to. She's very anxious to have you out. She says you've never paid any rent since you moved in October. You had a different version of that. But she wants you out. You can agree to a date other than July 7th. You also have 10 days to appeal this, Mr. Longacre. If you do move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving.
Yes, sir.
I will send you a copy of this. Do you have any questions?
No, sir. It's just that I can only work with what I have, and I mean, I know you're asking, you know, for the 15th, but the house doesn't become available to the 15th, and I was just asking for an additional 3 days to move.
Well,
I'm not contesting it. I just trying to do what you guys asked.
All right, I understand. She's not willing to bend. If she is, she can change her mind, but I'm gonna just follow the law here. Anyway, if she agrees to, maybe if you paid her some money, she might agree to extend it. But at this point, we'll just go with the 10 days from today. And I encourage you to talk to each other to try to make this as smooth as possible. All right, Mr. Groot, I'm going to remove you.
Okay.
All right. We were going along pretty smoothly and everything all happened at once. This is our last case, Barnett and Barnett. Barnett and Mock. This is file 21861. It's entitled Brandon Barnett versus Christine Mock. I think parties are both still in the same house. Mr. Barnett, can you hear me?
Yes.
Ms. Mock, can you hear me?
Yes.
This is the second termination of tenancy hearing. We learned last time, which was 7 days ago, that he's the owner of this property on Chicago Road in his sole name. There's no lease and he wants you to move. You're presently living in the same house. You have 3 children, one of which is his. And despite that, he wants you to move out of his house. And there is no lease, and by point of fact, he's entitled to the relief he's asking for, I believe. Ms. Mock, are you still there?
Yes, I am.
Have you found a place to go?
I was looking, and the one that I found in Coldwater is full. And I have no family that would let me stay with them.
Well, the law says you have 10 days from today to move. I'm going to explain something a little bit. I don't really take any joy in this, but I don't have the discretion to just do what I feel like. He owns the house. There is no lease. He wants you to move. And as I said, this is the proper way to do it rather than just throwing your stuff out the back door. You have to go through the court process. I have relationships that have split up where one party or the other throws all the stuff out in the driveway. Well, you can't do that. You're clearly a tenant here, so he is following the legal process to remove you. Whether I like it or not, he's following the correct steps. So you have 10 days from today, which is July 7th, to move or you're subject to being evicted. Let me tell you both this. Mr. Barnett.
Talking about extending it for a couple weeks.
All right, he can do that. Mr. Barnett, you have 56 days from today to ask for the writ of eviction. So you actually have 46 days, which is about 7 weeks beyond the 7th of July to ask for the writ. Then you actually have another 56 days before you serve it. So you do have flexibility to work with her through July into August to find another place to move. But if you don't get the writ within 56 days of today, you have to start all over again. But you do not have to evict her on July 7th. By the letter of the law, however, you can, but you have the discretion to wait for 56 days before you ask for the writ. Do you have any questions?
No, sir.
Ms. Mott, do you have any?
No.
All right, it must be very uncomfortable living conditions there. I wish I had a better solution to this, but he is entitled to the relief he's asking for. You do have 10 days to appeal this. And again, he has discretion to give you more than 10 days, 56 from today, 46 from the date of the writ. All right, when you do move, theoretically, you're supposed to turn in the keys and give your forwarding address in writing within 4 days. That triggers the security deposit law, but there is no security deposit here. This is just a tenancy that turned into a long-term tenancy. All right, you're both free to go.
Thank you.
Thank you. All right, Bettina, that's everything. Hopefully those checks will clear on those other cases and the people will get some emergency help. And we can't do much on the termination of tenancy cases or the land contract cases. I didn't know if there was some other program that would help with a land contract, but land contract purchasers are struggling just as well as renters are.
Definitely.
All right. Well, thanks for your help as always. I'll see you on Friday afternoon.
Yes, indeed. Thank you too, Your Honor.
All right, that finishes this portion of our landlord tenant calendar and civil calendar. I gotta step back and put all the notes in proper order before I turn over to the clerks. We'll be back tomorrow morning with a very busy arraignment and felony pre-exam conference day.